Thank you. We have everyone? Very good. All right, calling the matter at line 3, Save the Hill Group versus the City of Livermore and Lafferty Community, Inc. And I am joined on this panel by my colleagues, Justice Mark Simons, as well as Justice Henry Needham. May I please have the appearances of the parties? Starting
yes,
with...
Your Honor.
Go. No, that's all right.
Sorry, thank you. Yes, Jessica Bloom for Appellate, Save the Hill Group.
Very good. And for the respondents?
Good morning, Your Honor. Sabrina Teller for City of Livermore.
All right.
Good morning, Your Honor. Doug Strauss for Real Party and Interest, Lafferty Communities, Inc.
Very good. Now, the court sent out, rather, a focus order. And in the focus order, we indicated the minutes that will be, or the time allotted to each side. And I believe it's 15 minutes. And of course, if there are questions and we take away from your time, I usually am pretty generous about giving back additional time to the parties. But as to the respondents, how do you wish to divide up initially your 15 minutes?
Your Honor, Mr. Strauss and I have conferred, and he's going to address the first question, hopefully within about 5 minutes. And then I'm going to handle the second question with our remaining 10 minutes.
And as to the appellant, how would you like? Would you like to reserve any rebuttal?
Yes, Your Honor. I would like to reserve 3 minutes for rebuttal.
Okay. All right, this is an appeal from a Superior Court judgment denying the petition for a writ of mandate filed by the appellants in Save the Hill. All right, with that, you may begin.
Thank you, Your Honor. This case asks the court to decide whether the California Environmental Quality Act obligates the government to disclose and analyze the feasibility of using compensatory mitigation funds meant for the geographic area where a proposed project site is located when evaluating the environmental impacts of developing that site. Appellant and the Superior Court believe it does. With the benefit of review of the record and briefing in this case, the court has asked the parties to answer 2 questions during argument. I'll begin with appellant's answer to question 1 regarding exhaustion of administrative remedies. As an unrepresented, unsophisticated group of community members, appellant Save the Hill timely objected to the environmental impact report in a way that fairly apprised the city of appellant's position that due to environmental impacts, the Garaventa Hills project site should not be developed. In fact, over the years, several citizens objected to the project due to the environmental impacts of developing the site. For example, Helen Nelson, quote, spent quite a bit of time studying the EIR because she was quite a bit concerned about the destruction of the blessed few hills or knolls that the city promised to protect in the open space element of its general plan. According to Ms. Nelson, if you tear them up and half of them are gone and build houses all over them, thus ruining them, you're being completely irresponsible. Ms. Nelson explained her understanding that the Garaventa Hills were meant to be protected from development because, quote, they were a mitigation area reserved to be a home for the animals and birds displaced because of prior developments. She added, how many times and how often are the indigenous animals and birds going to be expected to move? These issues must be adequately addressed before you go any further with the proposed development of the hills. Carolyn Morgan expressed one of her concerns as, quote, the destruction of habitat when the hill is bulldozed to make suitable building pads, end quote. She wondered if the developer could sell the credits for the site to be built in a more suitable habitat, so this one could be, quote, saved forever. The Livermore Area Recreation and Park District commented regarding its concerns that development of the hills would have on drainage patterns to the neighboring Garaventa Wetlands Preserve, including the lack of drainage and polluted runoff from the subdivision. The Livermore Area Recreation and Park Department noted, given that the developer met with LARPD staff to discuss our needs and concerns, and our comments are apparently not incorporated in the plan, we request that the city address the issue of protecting and enhancing the wetland area east of Vasco Road. Until there is an overall plan for the area addressing hydrology and wetland integrity issues, LARPD is concerned with any housing development in the area. On August 18, 2015, Cindy Angers objected to the development because of concern about hydrologic impacts on the Garaventa Wetlands Preserve. She asked the city to convert the hill into open space and suggested the city use the hill as a mitigation bank for future development. Had the city disclosed that the hill was already located within the geographic area designated as mitigation for prior environmental injury, there is no doubt Ms. Angers very likely would have expressed her objection differently. These are just a handful of comments expressing objections to development of the Garaventa Hill due to concerns about the environmental impacts of developing the project site. Even though these...
Council,
Yes.
may I, it isn't your position, is it, that if there are any objections to the project, that automatically on its own alerts everyone to the failure to adequately discuss the no alternative issue, right? Saying that if somebody says there's hydrological problems here with what's going on, well, that certainly reflects a concern with the environmental impact report. But does any objection therefore automatically preserve an objection to the lack of discussion, adequate discussion of the no alternative approach?
No, Your Honor. If the comment had stopped at an objection based on hydrologic impacts, the appellant would not expect the court to accept that as an objection based on a faulty analysis of the alternatives. But the issue here is that we have an unsophisticated, unrepresented citizen group, and the courts in California have held that they're entitled to some leniency in this regard, that CEQA magic language, such as the words no project alternative or analytical gap in analysis, these types of legal terms of art are not necessary to be included in these citizen comments for the city to be fairly apprised of what the actual objection is regarding. I'll admit that I think it would have been very difficult for a citizen group to pinpoint their request as an alternatives analysis objection in the way that you would expect a lawyer to sort of understand that that's where they're trying to get the EIR to be revised.
So where do we go then? Where does it lie? That is, we understand that they're not going to be held to the same standard as if they were represented by counsel. On the other hand, I think you agree that it's not enough to say things like the hydrological problems aren't being met or adequately discussed. So what were the words that came close enough to focus them on the no alternative project, even though no magic words, no specific reference to no alternative existed?
Sure. In the brief, we pointed out several instances where the comments focused on questions about using conservation funding to preserve or protect the site as an alternative to development. Again, the parties the individuals who commented below didn't use the word alternative to development, but calling on government officials to conserve a parcel rather than develop it is certainly at least a synonym to alternative. And so we argue that's where the exhaustion
May I follow up
happened.
on the question by Justice Simons? Did the city respond to some of the comments by the citizens group? I believe there was a city council meeting and there was a planning commission meeting. Can you address that? When they raised the issues, did it get addressed at those meetings.
Yes, it
Virtual.
did. Yes, it did. Thank you, Justice Jackson. I think that's the crux and the key point here, that the city appears to have fully understood the petitioner's objections. At that April 2019 meeting where the city council actually certified the environmental impact report, and there's quotes from many of the meetings in the record that I have highlighted in our briefing and in a table that we provided to the Superior Court. But this 2019 meeting, I think, is really key because Mayor John Marchand acknowledged in this meeting that the city, quote, knew back in 2015 that Appellate was seeking funds to buy the Garaventa Hill property for permanent conservation, and that, quote, somebody at the meeting said that the funds are available, but I presume that would be the Altamont Open Space Funds. But there's a lot of very specific requirements behind that funding, correct? And that's the end of that quote. The City Planning Commission Secretary responded, quote, the Altamont Landfill Settlement Fund is tied to sites with, quote, native significant biological diversity and also non-motorized recreation, so trail access. The mayor agreed. He said, right. And most of the grasses there are no longer native, there being at the Garaventa Hill. So they're non-native grasslands. In so doing, Mayor Marchand implied that the Garaventa Hill would not be suitable for spending the conservation funding designated in the settlement agreements, despite its prior targeting as being within the geographic area for those agreements, and despite the fact that the city had purchased and conserved property just over the road that's almost identical in nature. So none of that analysis is presented in the written environmental impact report. Indeed, the verbal exchange is all that there is in the record, and the only reason we have that is because the meeting was recorded. Appellant believes that based on that verbal exchange, there's no doubt that there are three absolutely true facts here. One, members of staff and city council understood appellant's objection to the environmental impact report. Two, this allowed them to engage in an informal analysis of the merits of using conservation funding to protect the Garaventa Hill at that April 2019 meeting. And three, the staff openly declined to revise the environmental impact report based on that informal assessment. The city prejudicially abused its discretion when it engaged in that informal assessment of feasibility and refused to evaluate use of the mitigation funds within the written environmental impact report.
Council, could you, because you only have a few more minutes before you use up your rebuttal, could you address our second issue
Yes.
that was raised?
Thank you, Your Honor. The city's omission of relevant information regarding the feasibility of acquiring the project site as undeveloped open space prevented the city from making an informed decision to certify the EIR. Under CEQA's standard for adequacy, an EIR must be prepared with a sufficient degree of analysis to provide decision makers with information that enables them to make a decision which intelligently takes account of environmental consequences. In examining the EIR, the court must look for adequately, completeness, and critically, a good faith effort at full disclosure. According to the California Supreme Court, when analyzing the feasibility of alternatives, it's not enough that the agency is internally fully informed as to the alleged infeasibility of alternatives. The public must be equally informed. In Laurel Heights, the Supreme Court held that without meaningful analysis of alternatives in the EIR, neither the courts nor the public can fulfill their proper role in the CEQA process. Here, the city's argument is nearly identical to that of the Board of Regents in Laurel Heights. Both agencies claim they understood certain alternatives to be infeasible. Both agencies failed to discuss their analysis or provide the public with insight into the analytical route they chose to come to their conclusions in the written EIR. The Court of Appeals should reverse this EIR, just like the Supreme Court reversed the Laurel Heights EIR, so the city can include a written assessment of its feasibility analysis in the EIR itself.
So as I understand something, just one question. Going back to that city council meeting where
Yes.
a number of the members of Save the Hill appeared and testified or spoke, the mayor asked several questions. The city attorney answered those questions. Is it your view that those questions were adequately addressed at that city council meeting?
No, I think the city attorney was wrong at the city council meeting. He advised I think it was assistant city attorney, she advised the city officials that they weren't able to send the project back to staff for further review, that they were obligated.
Let's assume that that was correct. I guess even if she says that, they have to do more than just say that. They have to show why it's not, or give some rationale for that position. Is that correct?
That's correct. That's correct.
It wasn't put in the EIR.
Correct. Yeah.
Actually, I thought it was I shouldn't say this, but I thought it was very strange for, well, I wasn't there. I shouldn't judge it. I don't know, but I just thought the answers were so quick and short. You know, I can't put myself there. I was just saying, if I was there, that wouldn't be the end of the answer. But anyway, I wasn't there.
All right, thank you. So that we can stay within schedule, and I will give you 3 additional minutes after we hear from the respondent. Do you wish to, are there any further questions? I'm sorry, to my colleagues, before we turn to the respondents. Okay. Respondents, do you wish to argue?
Yes, Your Honor. This is Doug Strauss. May it please the court, I'm going to address the court's first focus question regarding exhaustion of administrative remedies, and my colleague, the city's attorney, Sabrina Teller, will address the remaining questions. The court's question is right on target. It asks whether the comments by the representatives of Save the Hill fairly apprised the City of Livermore of appellant's position. And respectfully, the answer is plainly no. And when we listen to the comments that are made, none of them meet the requirement that the actual issue being litigated now in this court be raised at the administrative level. The decision that the court cites in question number 1, Planning and Conservation League, actually is right on point on this specific question. It says that CEQA prohibits the litigation of an issue unless the alleged grounds for noncompliance were presented to the public agency. And the objections must be sufficiently specific so that the agency has the opportunity to evaluate and respond to them. During appellant's presentation, you heard that folks objected to hydrological issues. Folks objected to habitat issues. Folks objected to view issues. And all of those issues are indeed addressed in the EIR. And then when Justice Simons says, well, what specifically put the city on notice that there was something deficient in the alternatives analysis in the EIR? The answer from appellant is that, well, people said that they didn't want the project to be built and that they wanted the land permanently preserved using settlement funds or otherwise. That is a political comment rather than any sort of a cue to the city that we think there's something missing from the EIR. Yes, Justice Jackson.
Council, didn't they raise various settlements that had already been done and preserving the habitat, no development? And since this was one of the last developments in Livermore, or non-development or underdeveloped areas in Livermore, they raised previous litigation and asked, why could it not be done in a certain way? And as Justice Needham said at the City Council, when the Assistant City Attorney was able to address those answers very quickly and said, 1, it would require rezoning, which we couldn't do. 2, there might be litigation. So I think that they were more than just broad, I don't like the project, versus they're saying, and there was arguments being made at the City Council and the planning stage of why it shouldn't be developed, and there were other alternatives. The no development alternative could have been explored, and they were immediately addressed. So I don't think it threw the city off, and I think that they knew exactly what was being asked of them.
Well, thank you for your specific question, Your Honor. It is certainly true that the city knew that Save the Hill or other persons were asking that the project site be permanently preserved, and they were suggesting that the city could potentially use the settlement funding for that purpose. But that is a political ask. It's not a question about whether the EIR is missing a discussion about that. And the city's response is actually spot on. It may be brief, but it is extremely accurate. The city says, we have a project before us that complies with the current zoning, and in order to permanently preserve the land, we would have to rezone the land, and that would trigger a takings exposure on the part of the city.
Should that not have been in the EIR? That's the whole point. Agree or disagree, why wasn't that in the document? Because isn't that the whole point of having this report, that any person off the street who was not at the city council meeting can pick it up and say, oh, now I understand why they didn't develop, why they didn't leave that hill to all the wildlife up there, because it couldn't be rezoned. It was going to be litigation. Should that not have been in the report?
Well, I'm sort of spilling over into my colleague's question number 2. The answer, however, will be no. And the shortest version of that answer is that the reason that it's no is that you have to reconstruct a hypothetical situation that is inconsistent with reality in order to get there, because you have to rezone the project, you have to cancel the existing contractual relationship between my client and the owner of the property, and then you can start to create the possibility of a hypothetical acquisition for conservation purposes. So I don't think it needed to be in the EIR, and I'm sure Ms. Teller will do a much better job of explaining why, right. But that's a different question than whether the city understood that there was an attack on the EIR. The city understood that there was an argument that the city should exercise its political judgment to try to preserve the site. And the city explained why it did not want to exercise its political judgment to preserve the site. If the city had understood that the argument was you're missing a couple of paragraphs from the EIR, the city would have included those paragraphs in the EIR. Just like the city was responsive to hydrological concerns, the city was responsive to habitat concerns. The city was responsive to view concerns.
Council, my concern is, again, focusing on the question that you are dealing with, yes. It does seem a bit hard to make the argument that you're making. You concede, I think, that the city was well aware that they wanted no development, and the way they wanted no development was through using funds to purchase the property. There were arguments against that, but while it strikes me that makes it fairly evident that the issue had been exhausted, had been adequately raised, your response seems to me to be, oh, well, they were only talking about a political decision, I guess, as opposed to an environmental decision. That may be a distinction well recognized in the cases, but it seems it's a bit elusive to me when the decision is environmentally, or the issue is raised by the civilian group, the Save the Hill group. The issue is, why won't you protect the environment by exercising the authority that you have to purchase the property? How do we just dismiss that as a political rather than an environmental issue that needs to be addressed in the no alternative project section?
So I'm sure Justice Simons and the other justices are aware that the no project alternative discussion in the EIR does discuss the likely scenario of what occurs if the project isn't developed, and explains in that section that the land is zoned for development, and if this project doesn't occur, then some other project will occur, which is could be actually worse for the environment than the current project. So it's not true that the EIR ignores the idea of not approving the project. It is true that the EIR does not discuss the idea of rezoning the property, breaking the contractual relationship between my client and the owners of the property, and then going forward with some new alternative. Again, Ms. Teller will explain why that is not required, but a statement that we think the city should buy the land and permanently preserve it is different than we think the EIR should discuss that alternative. No one from the folks making that statement would have been unhappy if the city said, yeah, let's do that, but never put it in the EIR. They're not asking for a change to the EIR, Your Honors. They're asking for the city to exercise its political powers, essentially condemnation powers, to which could happen in every case, to go out and buy a piece of property that's not on the market. That's not an EIR objection. That's a take us off the hook here and buy this land for us. It's not saying there's something wrong with the EIR. The Sierra Club versus City of Orange says that general objections to project approval are not enough to raise the specific issue that you're trying to litigate. And nowhere is there any clue that there's a suggestion that the EIR itself is missing something from the no project alternative discussion. We're not trying to hold the appellants to some magic words that they had to say, but we are saying that they had to link their comments in some way to the EIR. They didn't have to say the no project alternative is deficient, but they did need to say that the EIR should discuss the option of buying the land. That's not complicated to say, and it is never said. No one says the EIR should discuss that option. What they say is the city council should consider that option. And the city council, of course, did. I suspect I'm way over my 5 minutes. I appreciate the questioning, and I'm happy to answer more questions, but I don't want to use up my colleagues' time.
No problem. And we asked a lot of questions. Council, would you like to address, I believe, the second issue?
Yes, thank you, Sabrina Teller for the City of Livermore. So following on from what my colleague has said, the lack of analysis of a preservation alternative in the EIR did not prevent the City Council from making an informed decision about the EIR or the project. As Appellant discusses in their opening brief, the city was well aware of the settlement agreements and those special purpose funds before the City Council acted on the project. And the reason Appellant was aware of this is because the city addressed those questions repeatedly as they came up, and it is in the entire administrative record. It's just not in the four corners of the EIR. And that is because, as Mr. Strauss pointed out, no one commented during the draft EIR comment period that the range of alternatives considered by the city was inadequate for its omission of the preferred preservation alternative that appellants are now suggesting is a legal flaw, that it's not there. And that is the whole purpose of getting back to the purpose of exhaustion.
May I ask a question? You alluded to the draft. This has gone through many revisions, or from withdrawal where the project was supposed to be, I believe, 77 units, then it went down to 47, down to 44. So when you say no one talked about the draft, wasn't the draft when we had 77 units and a different type of overpass and various other things?
Yes.
So it's a different project because you went back to the drawing board. Did they not?
They did. And there were multiple opportunities in all of these hearings and during the reissuance of the EIR to tell the city at any point, you're about to violate CEQA because of the absence of this particular
alternative. So is that what a citizens group is supposed to say? You're going to violate CEQA?
Yes.
Versus we object to certain things happening, and that's why this project has gone through so many revisions.
Yes, I'm saying that is the holding of the exhaustion cases, is that the whole purpose of the exhaustion requirement is to warn the city that some aspect of its CEQA compliance is deficient. And they did not do that. They expressed a political desire for a different outcome on the approval of the project, but they did not tie it to a failure to comply with CEQA. And that is required for minimal standards of exhaustion. But just because the specific alternative of using city money to buy the project site for preservation instead of development was not identified as an alternative in the EIR, again, because no one asked for it to be included, or alleged that it was required by CEQA, didn't mean that the City Council ignored the idea of preservation or that the EIR was deficient because of its absence. The city considered the question of preservation when it was raised, explained why it couldn't purchase the property using the settlement money, and determined that such an alternative was not feasible to further evaluate.
Should that not have been in the document? Isn't that
It didn't need to be, Your Honor, because I want to review the standard for elevating a particular alternative to consideration in an EIR. It's important to bear in mind that the CEQA guidelines instruct that the EIR must not create and analyze a set of artificial assumptions that would be required to preserve the existing physical environment. That's in guideline section 15126.6E3B. But that's exactly what appellant is demanding here. Permanent preservation was not the foreseeable, feasible consequence of denying this project proposed on land already zoned for development. As noted in the Planning and Conservation League versus Castaic Lake decision that the court cited in your first focus question, the EIR need only consider a no project alternative that preserves the status quo. And in that case, it was the, quote, currently effective contractual regime. This is in the court's discussion at pages 246 to 247 of that opinion. Here, the existing zoning and designation for the future development is the status quo for the site. And both the no project alternative and the less intensive alternative that the EIR analyzed considered the two most foreseeable scenarios: that the site would continue to be undeveloped for some undefined future period, or that it could be developed at a level entirely consistent with what the existing zoning and land use plan said. And the second of those scenarios, I think it's really important to note here, is actually what the council ended up approving. CEQA requires the lead agency to evaluate a reasonable range of potentially feasible alternatives. It doesn't say that the lead agency has to analyze infeasible alternatives. It actually instructs operates in subsection A.
Counsel, isn't this where the Farber the issue regarding the Farber land and what happened to that comes into play? And that is, appreciate that at the time that the EIR was drafted, the current piece of property, the Garaventa Hill piece of property we're talking about, was zoned residential. But that didn't make it infeasible, it would seem to me, to see that land being rezoned and then purchased or whatever. And the best example of that is what the city had done with the Farber piece of property.
Yes, addressing the Farber discussion that was discussed at a September 2015 City Council meeting, and the council and planning staff had a dialogue about that project. But notably, as I recall in that discussion, planning staff were explaining, in order to preserve any land under these settlement agreements and using those funds, there has to be a long list of steps that occur, including, most significantly, the city designating this site as a target for acquisition. And in order to designate it as a target for acquisition, it has to meet certain criteria. It has to have biological diversity, it has to have access to non-motorized recreation. And there was no evidence in this record yet that this site met those criteria, or that the city was required to put that site as a target for acquisition. I think it's important to bear in mind here that we're talking about assuming that the city is required to exercise its discretion in a particular way with respect to proposing and elevating and processing certain sites for acquisition under the settlement agreement. And the settlement agreement does not require that. It allows agencies to propose sites for it, but it does not compel them to do that. And so getting back to what the city's duty was under here, under this project, under CEQA, one note that the CEQA guidelines, where am I? Lost my spot. Sorry. The most important criteria for elevation of a particular alternative in an EIR, which is what Appellate is claiming the city was required to do, given what they had said about preservation. It has to show that an alternative is potentially feasible, and most importantly, that it would feasibly attain most of the basic project objectives. So you start with what is proposed for the site and what are the objectives of that project. And here, most of those objectives were focused on developing housing. And so there's no evidence that a preservation alternative, putting it out of reach of development forever, would meet any of those basic project objectives. And so there's no legal duty to consider the preservation alternative that appellants are now, framing and fleshing out in the course of this litigation, but not below. There's no indication that that was potentially feasible and that it would have met any of the basic project objectives. Now, had they exhausted on this point, had they said, here's how those objectives could be met, or, more emphatically, more clearly stated, we think your EIR is inadequate because of its omission of this particular sort of extreme version of the no project alternative, the city could have had that particular conversation about its legal duties under CEQA in the context of comments on the EIR or comments on whether the EIR should have been certified. But they didn't do that. They were framing it instead as, we don't want you to approve the project, we want you to put it out of reach forever. But they didn't connect it to illegal failing under CEQA.
Okay,
And they're required.
Counsel, I'm sorry to interrupt, but I have allowed the respondent to go 5 minutes beyond what was allotted to you. So I am going to have to now turn it over back to and give the appellant 3 minutes. I believe you reserved. Thank you very much. Sorry to interrupt.
Thank you. I'd like to make just a handful of points. The Castaic Lake Water Agency case is a good case for everyone to review because, as my colleague pointed out, in that case, the court held that the EIR fully disclosed the currently effective contractual regime at issue in the litigation. And so in light of the fact that the contracts were disclosed to the public failed to identify an analytical gap between the analysis and the conclusions that the trial court reached. We don't have an analytical gap here because we don't have disclosure of the currently effective contractual regime. And the appellant is not making an argument that the city erred in not selecting a conservation alternative. We are not dictating an outcome here. What we're asking for is full information for decision makers and the public so that they can evaluate what the city has already obligated itself to in the context of environmental review of a parcel that's, by all accounts, qualifies for use of these funds. At the core, it seems that the city is sort of eschewing any responsibility for complying with these contracts. And that's what interested me in the case, and I think that's what's probably everyone's feeling when they're evaluating this. The inherent in that argument is their just refusal to accept responsibility for these contractual arguments. Indeed, all of their objections to our arguments can be really summarized into failing to undertake requiring the court to undertake an analysis of extra record information that's not available to us because of their failure to disclose and analyze in order to kick back the case and get rid of appellant's arguments. The lack of a willing seller, the alleged lack of interest of the settlement partners, the alleged economic value of the parcel, all of that information would be analyzed and included in the EIR if they complied with their own set of criteria for evaluating the feasibility of conserving this site with those mitigation funds. In fact, one of the questions that my colleague highlighted on the list of criteria is, quote, are the owners of the parcel aware of the concept of conservation easements and the availability of funds for that purpose? Whose job is it to tell the owners that there's these conservation funds available, if not the city when the owners approach them with a question or a proposal to develop the site? It's not the public's job. And so we would argue that this is a prejudicial error and reversal is warranted. Thank you.
Thank you very much, counsel. Thank you very much. My compliments to the attorneys on this matter. The matter is now under submission. As I said, we have thoroughly read your briefs and we will have our decision. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honors.
Thank you. All right. We